Hello everyone, my name is Luis Pedriza. I am an associate professor of law at the Dokkyo University Faculty of Law in Saitama Prefecture, Japan. First of all, I'd like to thank you for attending my presentation. I am very aware of the inconveniences of holding an international meeting via the internet. Also, I'd like to apologize for doing my presentation in English and not in Spanish, which is my first language. Originally, I had prepared this talk in English, so it was my plan to get it translated into Spanish, but for time-related reasons, though, I couldn't manage to do so in time, so I decided to go ahead with the English version. Without further ado, let me talk you on the contribution of Japanese constitutional law to the concept of human dignity. To begin with, let's talk about human dignity. Human dignity is a foundational concept of human rights law. As most international human rights instruments adopted by the United Nations proclaim, human rights derive from the inherent dignity of the human person. Human dignity also appears in main regional instruments for human rights protections. Human dignity, or an equivalent expression, is also the cornerstone for rights protection in most national constitutions enacted after World War II. Interestingly, though, none of the aforementioned documents define what dignity is, although its etymological roots as a concept are well known. The word dignity stems from the Latin noun dignitas, which means worth, which in turn stems from the Latin adjective dignus, which can be translated as worthy, which in turn is related with the Latin verb decet, which means it befits, which is in turn, by the way, cognate with the Greek verb dehome, which means I take. The Indo-European root of the word is, according to most scholars, dek, D-I-K, which is the meaning of accepting or taking. Other related terms with this word dignity are, inter alia, the Latin verbs disco, which means I learn, and dokyo, which means I teach, and the Greek verb doko, which means I show. Dignity's etymology notwithstanding, the concept of dignity as a concept, has classical Greco-Roman roots. Its development in Western thought has widely influenced by biblical conceptions of man as imago Dei, the image of God, man as made in the image of God, and in its contemporary understanding, human dignity is mostly associated with the figure of the philosopher Immanuel Kant, the philosopher of the Enlightenment Immanuel Kant. In this presentation, I shall introduce how the modern concept of human dignity has entered Japanese constitutional law theory and practice, and I also give a brief account of relevant case law in order to show how this concept, even though it is not explicitly mentioned in the Constitution, in the Japanese Constitution, has served to expand the catalog of constitutionally protected rights, particularly in the sphere of private life. So let's talk about how Japanese legal thought, constitutional legal thought, has contributed to the development of the concept of human dignity. Thus far, Japan has had just two written constitutions as its fundamental law. The Constitution of the Empire of Japan, also known as Meiji Constitution of 1889, and the Constitution of Japan, the current Constitution of 1947. The Meiji Constitution represented the pinnacle of the process of legal modernization upon which Japan embarked in the second half of the 19th century, and that transformed the country beyond recognition. The Meiji Constitution was essentially based on German models and provided for a form of mixed constitutional and absolute monarchy, where the emperor was the tenno, was the supreme ruler of the nation. The document also included a catalogue of constitutional rights such as freedom of religion, freedom of speech, freedom of association, property rights, and freedom of movement, although those rights were granted to citizens because they were subjects of the emperor, and not because they were inherent. Those rights were inherent to individuals as rights stemming from human dignity. Moreover, those rights were to be exercised within the limits of public order, and they were defined by the law, statutory law. So they could even be restricted through imperial action. It goes without saying that judicial review, constitutional review of legislation, and governmental action was not existent in Japan at that time. When Japan was defeated by the Allied powers after World War II, the nation was placed under occupation until it was remade as a true liberal democracy, which could never become a threat to the post-war international order. Japan's occupation forces, led by Douglas MacArthur, pushed forward a number of legal reforms, including suggesting a fundamental revision of the Meiji Constitution. Even though at first the Japanese government was reluctant to any change, eventually it did prepare some proposals for constitutional amendment. Those proposals, however, turned out to be minor revisions, so MacArthur decided to prepare a constitution draft which would serve as a model and hand it over to the Japanese government for consideration. The Japanese government decided to support the constitution draft and started a regular amendment procedure of the Meiji Constitution. As a result, the pre-war constitution was revised to become the Constitution of Japan, which has been in force since May 3rd, 1947. The Constitution of Japan, in Chapter 3, Articles 10 to 40, sets out a wide variety of provisions under the common heading of rights and duties of the people. As a document made at the end of World War II, Chapter 3 should be understood against the backdrop of a resurgence of natural law ideas, which had begun to gain momentum in the international sphere as a response to the dominance of pre-war legal positivism. It is not coincidence, thus, that the terminology used by the Constitution to refer to those rights and freedoms is that of fundamental human rights. Fundamental human rights under the Constitution are construed as rights inherent in all individuals, qua human beings, regardless of their particular gender, age, national origin, social status, or economic condition. Unlike the Meiji Constitution, fundamental human rights are guaranteed by the Constitution, not granted by the emperor. In this regard, I think it is interesting to compare the list of rights and freedom recognized by the Japanese Constitution, on the one hand, as shown in Table 1, to the list of human rights mentioned by the Universal Declaration of Human Rights and the two international covenants on human rights, ICCPR and ICSCR, as shown in Table 2. Apologies for the font size. I understand both tables are difficult to read, but we can have an idea regarding to what extent the Japanese Constitution, both in quantitative and qualitative terms, lives up to international standards. It is a modern constitution in terms of right protection. Fundamental human rights guaranteed by the Constitution are rooted in its Article 13. This provision begins by establishing a fundamental notion of respect for people as individuals, then adds a variation of the well-known phrase of the US Declaration of Independence and refers to a right to life, liberty, and the pursuit of happiness. Regarding the interpretation of Article 13, it will look at how this provision was initially conceived in MacArthur's draft, originally Article 12. We shall notice that its original goal was essentially to proclaim the Constitution intention to do away with certain feudal structures of pre-war Japan. However, as soon as the second half of the 1960s, this provision began to play a more dynamic role in constitutional interpretation, with the result of precipitating an expansion of the scope of rights protected by Chapter 3. Current interpretation of Article 13 orbits around two essential questions. What does it mean that citizens should be respected as individuals? And what is the content of the right to life, liberty, and the pursuit of happiness? Regarding the first question, most scholars concur on the opinion that behind the phrase respected as individuals lies the concept of human dignity, as referred to by international human rights law documents. As for the second question, the right to life, liberty, and the pursuit of happiness, usually simplified as the right to pursue one's happiness, is conceived as an abstract right which may serve as the constitutional basis for supporting rights not enumerated not non-listed by the Constitution. Both human dignity and the right to pursue one's happiness conform what constitutional scholars see as the concept of individuality or personality, jinkaku in Japanese. Individuality represents the elements of character and personality that come together to define each person as an individual, and which represents the aspects of everybody's life and the government and that the government must respect in the exercise of its power. On the other hand, since anybody can be an individual in countless ways, ranging from the insignificant elements of one's life, such as hobbies and interests, to the essential ones, such as ethnicity, religion, sexual orientation, and so on, the key question arises as to what extent has the government to respect people as individuals in order to protect everyone's right to pursue happiness. We can identify two contrasting doctrinal approaches in this regard. First, some scholars argue for a limited understanding of Article 13. Under this approach, Article 13 protects only those interests that are essential to identity, namely the critical core of one's individuality. Other elements, such as hobbies and interests, are outside the scope of constitutional purview. Secondly, other scholars argue for a broader understanding of Article 13. They recognize a distinction between core and non-core aspects of individuality, but by replicating American jurisprudential methods, they argue for a two-tiered approach. Thus, essential elements of individuality are to be protected by a strict scrutiny approach, whereas other aspects of individuality should be subject to a rationality standard. On the other hand, Japan does not have a constitutional court specialized on adjudicating on constitutional issues. The system of judicial review or constitutional control in Japan resembles that of the US, where courts of all levels may judge the constitutionality of laws and governmental action. Case law on Article 13 has expanded the area of constitutionally protected rights to include freedoms related to private life. In particular, we can distinguish three areas of litigation where courts have played an active role in identifying rights related to private life. First, rights to privacy. Second, rights to individual self-determination. And third, rights to control of personal information and sensitive data. I shall introduce some leading cases which cover those topics. The first case is the so-called After the Banquet case of 1965. In this case, novelist Yukio Mishima was sued for damages by a famous politician who claimed Mishima's novel After the Banquet, Utage no Ato in Japanese, had invaded his privacy. The Tokyo District Court found in favor of the plaintiff in what became the first judicial recognition of a right to privacy, which stems from Article 13. The second case is the Zengakuren Kyoto branch case of 1969. Here, when assessing the constitutionality of a photographic recording by police authorities of a political demonstration, the Supreme Court acknowledged that individuals have a right not to be photographed without consent, and that such a right stems from a more general right to privacy. In the case at hand, however, the court found police action was justified. The next case is the Hoppodianarcase of 1989. Here, the Supreme Court ruled that the local politician who was running for office could successfully obtain an injunction against the publication of a magazine when it was obvious that the content of the publication was not true, when the publication did not pursue a public interest, and when the victim could suffer serious and irreparable damage to his honor and reputation. In other words, in the court's opinion, honor and reputation are elements of the concept of individuality. We also have a case of 2000 about a Jehovah Witness blood transfusion. In this case, the Supreme Court ruled that the public hospital could not force a patient to undergo a blood transfusion against her religious convictions. The plaintiff, who was a Jehovah's Witness, had a liver tumor removed at the hospital after the doctors were guaranteed she would not need a transfusion during the surgery. During the operation, however, due to blood loss, the doctors had to perform a blood transfusion on her. The court determined that the hospital's failure to abide by the patient's desires amounted to a violation of her right to individual self-determination, which also stems from Article 13. Finally, as a more recent case, I'd like to talk about the Dukinet case of 2008. In this case, the Supreme Court ruled on the constitutionality of the basic resident registration network system, known as Dukinet, which is a computerized network across Japan that shares basic information on local residents, making it possible for various administrative institutions to have access to such data. There were concerns Dukinet might bring about potential violations of an individual right to control of personal data as protected by Article 13. Nevertheless, the Supreme Court determined that the system's purpose was rational and that reasonable steps had been taken to detect and prevent any potential misuse of sensitive data. Now, let's move on to the conclusion. Ever since its promulgation, the Constitution of Japan has come up against criticism by some conservative quarters of Japan's society. In fact, enacting a new constitution has been a foundational principle for the LDP, the political party which has almost uninterruptedly governed Japan since 1955. According to LDP's understanding, since the constitution was forced upon Japan by foreign authorities, it espouses philosophies which are alien to Japanese traditional values. For example, Article 13's avowed defense of individuality and individualism does not fit well in a society traditionally known for its group orientation. These conservative opinions notwithstanding, Article 13 is one of the most cherished elements of the Japanese constitution, both for legal theorists and practitioners. Article 13 has served as the key provision to avoid the constitution obsolescence. In this sense, it is foreseeable that current understanding of Article 13 will continue to play an essential role in deciding hot issues faced by the Japanese society, such as LGBT rights, euthanasia, and surrogacy. Regarding LGBT rights, on Valentine's Day 2019, 13 same-sex couples brought suit simultaneously to different district courts nationwide. According to the plaintiffs, the ban on same-sex marriage constitutes a violation of Article 14 and Article 24 of the Constitution. The former provision establishes the principle of equality before the law and non-discrimination. According to mainstream interpretation, Article 14 bans different treatment based on unreasonable grounds. So different treatment based upon sexual orientation amounts to unreasonable discrimination. That's what the plaintiff says. As for the latter provision, Article 24 guarantees freedom of marriage. Regarding Article 4, though, it is worth noticing that since this provision establishes that marriage shall be maintained through mutual cooperation of husband and wife, some argue that the Constitution's language presupposes that marriage should be between persons of different sex. Former Prime Minister Shinzo Abe, who has fought to alter the Constitution on matters of security, namely Article 9, it is less eager to oppose the Constitution principles when it comes to same-sex marriage. In his opinion, changing the Constitution to allow gay marriage would require extremely cautious consideration. At any rate, since sexual orientation is profoundly linked to personal identity, constitutional grounds for same-sex marriage could be found on Article 13. And since sexual orientation belongs to the core of individuality, courts should apply an exacting standard of review when analyzing whether the legislature's refusal to legalize same-sex marriage might constitute a violation of the principle of respecting citizens as individuals and the right of pursuing one's happiness. We should not be extremely optimistic, however, about the outcome of this series of lawsuits. It is notorious that the Supreme Court has held legislation to be unconstitutional in only a handful of cases since the Constitution's promulgation. Nevertheless, this series of lawsuits may serve as a catalyst to increase social awareness of the plight of many sexual minorities all around Japan, and may also trigger legislative changes. I shall conclude with this, my presentation. Thank you everyone for your attention.